Hello, everyone, and welcome to episode 13 of my narrated series with an LED crystal ball from the Dollar Tree. And my theme that matches all of it so well that I also found at the Dollar Tree. As I say, with these things that the Dollar Tree has this season, it goes fast. So if you see something at the Dollar Tree one day, don't think you'll be able to come back. Just go and get all those quarters out of your car and buy it if you have to, because it is going to be gone the next time you come. And then I'm matching it with this purple Starbucks cup. I think, was this one from spring, maybe spring of this year? I wanted to get as much as I could out on this lawsuit before the next hearing. And as you saw, I had no idea so much was going on. So that's where, I'm having to break this all down, go back and make sure I have everything, research what is said so that I can bring you every single thing, because she's got her poker face or whatever it is with her face going on, where she is not letting anybody know that this is this bad. Pacer, as she wants to use to defend herself, Pacer would be something that would very much work against her at this point, as attorneys use Westlaw, LexisNexis, and Pacer, as I discussed in the last episode. So when you call an attorney and you have a possible case, the receptionist will ask your name, ask your address, and ask who you intend to file a suit against, and their address, and basically what you're wanting to take legal action about that person is about. In the time before, and they'll say, and an attorney will call you back. In that time that happens between when the receptionist takes your call and an attorney calls you back, they generally will have checked Westlaw, LexisNexis, and Pacer to see if either you or the person that you intend to file against has a history of filing similar lawsuits, and they will see what kind of behavior pattern you yourself shows. They will see if the person is worth going against. They may see, that they don't have any assets or anything like that, and say, look, well, you could get if they see that the person has no assets and that they are successful in every lawsuit that's ever been brought up against them for a similar action, is you'll just get a letter in the mail that'll say, thanks for contacting our office. We have chosen not to represent you in this case. This is not to say that you don't have a case, but it's just to say that we will not be representing you. So what will happen now is that Katie Joy is marked because of the history. Like I say, people think, and she likes to say, that she won against Tati. She didn't. Tati gave the first blow, and she gave her a liver punch, because Tati did some damage, and that lawsuit is in there for other attorneys to see the mistakes and learn from them. And that's why we now have a properly formatted lawsuit in the correct jurisdiction, in the jurisdiction in which she resides. So the attorney would also have to decide, do they have the ability to file suit against this person in a different area, in a different jurisdiction? Can they afford to go there for hearings? Can they, do they know what the courts are like in that area and what the demographics are? There's a lot of research that goes on between that and that. So now what will happen, especially before this case settles, because we don't know how this is going to settle out. If somebody were to come right now, like say the Sister Wives, maybe, or any of the other Duggars, maybe. Hello, hint, hint. If they were to file a similar lawsuit right now, the attorney would look and see, holy moly, all of these are filed against her and it's showing that she has this pattern of behavior. They might take a quick look to see what's going on and say, hey, I want to be in line for what she's going to give up. I want to be in line if her insurance pays out. I want to hit this like a freaking piñata, and yeah, I'll take your case. Now, they could also say, well, how much can we get? Because she's worth this much. Her insurance, and they may be able to look into how much her insurance could pay out. But as we now are hearing, there are provisions in the insurance that may not cover her. And this could be a secondary hearing where her insurance may get sued for that, to say, you know what, you chose to represent her and you saw that she has a history of this pattern of behavior and you still did. There's all of these secondary and tertiary things that are going to go on. My opinion right now is that she is trying to create the narrative to best defend herself in an upcoming trial. If she writes stories and puts them out for anybody to pick up, that quantifies her as a journalist. Okay? So I'm very suspicious of what Utah Fox 13 just did. I think that's what they're called. If I am misspeaking, I'm sorry, but I think it was a news station out of Utah, and I believe it was a Fox 13 channel. They referred to Katie Joy as a journalist who reports on child abuse stories. That right there is false, and they did not check their sources. Is Katie Joy purporting herself as that? Is she saying that? What other child abuse cases has she covered? Now, I'm going to say allegedly to protect my ass so that I'm not reading these things about myself, because allegedly, you can see the other YouTubes and look in, allegedly, Katie Joy herself has been accused of child abuse. It is my opinion that the ways in which her husband was overheard screaming at their medically fragile son, as she refers him to, does constitute, at the very least, verbal abuse. That is my opinion on that. And that is why I unsubscribed for her and why I started looking more thoroughly into her and her stories. As I did so, I saw that she goes to the same children's hospital in which I took my children for their issues that they had from being premature, and my son who has cerebral palsy. And my experience for my children was that I felt almost guilty, for having premature babies, because I was always like, could I have done something more? Could I have noticed something? I blamed myself. Premature labor is very, very different than regular labor. It is pressure. So if you are pregnant and you feel pressure, much like Braxton Hicks, but you feel a pressure that then is able to be timed like labor can be, or if you have spotting of any kind, contact your provider. Go to the emergency room. They will take you by a wheelchair up to the mother baby unit if you're too far along, but just go to the hospital if you have any questions. I felt then, I made so many deals with God because I felt like my boy twin was not alive at that point. And so as they were preparing me for the C-section, in their words, to see what had happened to my boy twin, I made every deal with God that I could. And I promised him, I said, if you give him to me, I will take him in any form. I will care for him and I will love him and I will optimize his potential. I will do everything. Please, 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 please let him be mine. And he was born with 50% oxygen. He was blue, but he did cry. I'd been in the hospital for 6 weeks at that time, so I'd gotten the medication to mature his lungs, etc., etc. But I then realized that it was my duty, and I was chosen to optimize his potential. And I never once made him feel like a burden. I would never, ever allow myself or anybody to speak to my medically fragile child in the way that she did. Now, as he's grown and he's not medically fragile, he just doesn't feel much of his left side. He has cerebral palsy. That will not change. He had a stroke in utero. And as you all know, I had my three youngest 2 days less than, I'm sorry, I can't speak right now. I had my three youngest children in 2 days less than 1 year. So 3, 2, 1. 2 days less than 363. So those are my lucky numbers, 2, 3, 6, 3. So going to the children's hospital was something that I made a fun day out of. And they had a great time because the hospital makes it that way. There are so many things they have. They have all these aquariums and these little things to look at, art, play areas, everything. So even if they weren't, in the area where I needed to be, I'd make a note of where those play areas were. So then after the appointment, I'd let them just go and play in those areas. And, I'd read a magazine or do whatever and let them play. And especially let them play with children who were differently capable than they were. And they had a great time. They were accustomed to their little brother needing a little help. They never understood child gates. I would put child gates so that they wouldn't get into the other areas of the home where I was trying to work in one area and I could still see them. They saw that I did the child gates. They thought it was an obstacle course. So the one who was a little 363 days older would pull the girl twin over and she would do her best to kind of climb, but then he'd pull her over and then they would both pull him with cerebral palsy up and over. And then they'd be in the room that I was trying to get something accomplished in. They wouldn't be in their toy room, and just nonstop. I'd have to go to Home Depot almost every day and get bigger nails and bigger. Home Depot probably thought that, I had a whole entire adult in the basement because I was like, yeah, I need a bigger screw and a bigger, some plaster. I need this, yeah, nails got pulled out of the wall again. Yeah, didn't we just get, yeah, you did, I need some bigger ones. And they're like, what the hell? My wall looked like Swiss cheese. But that's how they did things. And so it was no different when they went to, Gillette Children's and they saw other kids who couldn't quite do this. They would just help them along. And that was how it was. And my girl twin needed some surgeries there. Plastic surgery. She had a birthmark, a hemangioma on her face and wrist. And so she had, multiple procedures and plastic surgery. And so they loved going on their appointments. They were fun. So when I heard Katie Joy referring to the same place in which I had been as like a nuisance and her having to go there in the ways that she would, it pissed me off because it should be her priority to optimize her child's condition and make those appointments fun so that he doesn't feel like a burden. Because if you ever make a child of any capability feel as if they are a burden, that sets an adult up to feel like a burden. And when somebody feels like a burden, it's a difficult way to live life. They should feel loved, adored, and treated like absolute preciousness. I didn't see or hear that in Katie Joy's recollections of interactions with her son. And I certainly didn't see her spending the time with him that she should. I saw her spending the time online. I started my channel when my twins were 18 years old. specifically because I did not want to be subjected to the false CPS reports. It is ridiculous when a false CPS report is filed, especially where I live, especially in Wright County, because they are overworked and overburdened, as any child services is, but they are particularly derelict in their duty. I have known many children who are actually completely abused, and the CPS in our area does nothing. I opened my home to those children, and not officially. It was like, you know what, you're not doing your job, so come and get them. You'll have to get through me. And I protected those children because CPS wouldn't. So when people did report her and they didn't get any answers, that's no surprise. That's Wright County. It is my opinion that she does not work to optimize her child's potential. With my children, they were in physical therapy, occupational therapy, and speech therapy 3 times a week until they were 3 years old. They didn't have in-home therapy. I brought them, so even though I was very, very sick, had a nephrostomy, if you guys know what that is, for a while, badly needed a hysterectomy but didn't have time, so the therapist would help me put, plastic pads where I would need to sit down, like plastic pads on the chairs and the mats, so that I could kind of lay down to my side, and because the feminine products would not hold, and I'd have to go to the emergency room when I could get a babysitter because my husband was at sea, and they'd have to put, the coffee ground things to try and help me stop bleeding, but I didn't have time to get a hysterectomy, so I still took them even though I was very sick, and getting all 3 of them in car seats and all 3 of them in a stroller and getting all 3 of them fed and everything else was not easy on me, but I made them feel like this was their day every day. And it was my privilege, and it is my privilege, to have raised them. And I feel like that's something that Katie Joy had the opportunity to do because she could work from home. But it is my opinion that she started using YouTube to disassociate from the situation, and she did not take the opportunity to take the tools that she learned in physical, occupational, and speech therapy and bring them home to use, because you can go to therapy, but then you need to put it in practice at home for it to work. And I do know that that did not happen based on her own recounting of not appreciating the physical therapy. Gillette is amazing at physical therapy. If for some reason she didn't like the therapist or whatever, they're all amazing, she could have asked for another one. But you have to do your homework, and they can tell if you haven't, because, they're, and so my child couldn't eat because he couldn't chew in the left side of his mouth, but they worked and worked to find what he would, because I wouldn't allow a feeding tube. When they put NG tubes in them when they were preemies, they would rip them out of each other. The little twins would be there in the crib. They finally, because I would not allow them to be separated. They had to be separated the first 24 hours of their life, because my boy twin needed more intensive oxygen therapy. He needed BiPAP, as his oxygen was still 50% at 4 hours later. I would sit there, and even though I had a nephrostomy and I was getting ready to go into surgery after they were born, I would take that time. I would feed them. I would be sitting up when I had doctor's orders to not, because I did not want them to even have an NG tube, let alone talk of a feeding tube for my child with cerebral palsy. It wasn't going to happen. I would feed him. And I did. And we learned, and he eats the foods that he does, and he still eats weird foods, so that's why you sometimes see me showing some different things that I have to make, like the burritos that I'm making, because he doesn't really like the texture of meat at all. It's just too much. Textures and stuff are hard for kids with sensory defensiveness and whatnot that were preemie. So you work with it, and you work with what foods they can eat, and you work with it, and you don't give up. It is my opinion, shared with others, and I am not a medical doctor, but I am a mother who's had a similar situation, in that I believe that she did not give her child what was recommended and wanted him to have a feeding tube for ease of use, and then she could have a nurse come to the house. It is my opinion that she could have done better. It is my opinion. She can do better. And that is my hope in all of this, is that she does do better by her son. That being said, I know that people think that the religion is lumped in, and the religion itself is only because of Katie Joy lumping religions into other people's behaviors. I have here one of the books. I am not Mormon, but I have a lot of Mormon friends, and I would have loved to have been Mormon in a different life. It's just, I was raised Catholic and baptized Catholic, so I can't quite be a Mormon, but I am working on different things to cite in when I do coverage of Katie Joy and how she's maligned Mormonism and such. I will work to set the truth in that, and I would love to set the truth forward about the Shekinah Church. Did I say that right? I know that I mispronounced it once. I hope I'm doing it. If somebody can send me material that they think is relevant for the Shekinah Church that I should know, that I could add some truth, impart some truth, please let me know. I will get to it. I will find research on it. But for right now, if somebody could send me something that, or some people could send me some things that they feel are important to be incorporated into my expose with an LED crystal ball. My email is TabithaJane0@gmail.com. And without further ado, here is part 13. Now we're going to get into two sections written by Jennifer Moore. So this is written by Katie Joy's attorney, who was very, very busy last Halloween into the first week of November. These are short, so I'm going to do two of them. This is authored by Jennifer Moore. So here we go. And I'm going to show you the date here on this first one. This is dated November 4th, 2022. So we are a year back. And this was written by Jennifer Moore. And it states here that we are in the state of Minnesota, County of Wright, in the District Court, 10th Judicial District, in a case type of default, in a case type that's civil. And this is defendants' memorandum of law opposing default judgment. The plaintiffs are 7M Incorporated, Robert Shin, Miranda Derrick, and James Derrick, versus the defendant, Catherine Mansky Paulson, all aka Katie Joy, and Without a Crystal Ball, LLC. It is listed as defendants. This is one person and her insurance company, basically. And I don't know if this is why it is listed like that, because it will be the insurance company that pays out, if that's why there is a plural in the defendants, because it is Katie and her company name. It is not necessarily different people. It is all her in all of the accounts that she uses and all of the sources that she pulls straight from her. As anyway, the introduction says, despite the fact that defendants have actively participated in this litigation, including serving discovery and filing a motion to dismiss, plaintiffs have brought this motion for default for defendants' technical failure to file an answer within 14 days of the issuance of the court's order denying defendants' motion to dismiss, filed on August 25th, 2022. Okay. So right here we have Jennifer Moore going, that's a technical issue. That's a technical foul. It's not right. Why should we have to do that just because the rules say so? Just as she did when I went to the hearing and said that she was on vacation and came back and it was all like that. What was she supposed to do? Okay? This is how we're going. Maybe playing dumb and playing the victim works for her, because that's the way that she's playing this. A strict judge would have said, none of this. Because you missed this deadline, boom, default judgment. I order in favor of the plaintiff. This is done. But we seem to have something different going on in our courthouse, don't we? The procedural history states, plaintiffs brought this suit on March 31st, 2022. The complaint, as amended on April 5th, 2022, alleges defamation per se, tortious interference of contract, commercial defamation, intentional infliction of emotional distress, negligence per se, deceptive trade practice, intentional interference with prospective advantage, and injunctive relief. Yeah. Yep. Amber Slavik came to play ball, didn't she? Okay, let's go through this. Because when I go forth and I brief this entire case, this is important to see what all they have done. And now where it says here, instead of answering the complaint, defendants filed a motion to dismiss on April 26, 2022. The court denied this motion on August 25th, 2022, but did not issue a deadline for defendants to file their answer. Okay? So here Jennifer Moore is going to say this is technical. This is a technicality because, well, the court did that. They did not issue a deadline for defendants to file their answer. All right, there we go. Did they or didn't they? Nevertheless, defendants' counsel executed its answer on September 2nd, 2022, but failed to file the answer. Okay. So you did it, but you didn't file it. Okay. So you did it, but you failed to file the answer. Now, whose frickin' fault is that? Well, who didn't file the answer? Where it says over here, things were filed 11/4, and it was done on the 2nd. But 11/4, so that's a whole month later. Tisk, tisk, tisk. On September 30th, 2022, without contacting defendants or indicating that they would be bringing a motion, plaintiffs filed the instant motion for default judgment. On the next business day, counsel for defendants contacted plaintiffs' counsel to request that the motion for default judgment be withdrawn. Okay? And that is in the Martin Declaration, Exhibit 10. On October 5th, 2022, defendants served and filed their answer. Plaintiffs never responded to defendants' counsel letter requesting that the default motion be withdrawn. Okay, this is important because you know what? They don't have to contact the defendants. They went straight to the court. The argument is, in general, the Minnesota Rules of Civil Procedure require that defendant shall serve an answer within 21 days after service of the summons upon that defendant. And that is stated in the Minnesota Rules of Civil Procedure 1201. Because defendants filed a motion to dismiss, the answer became due within 14 days after service of notice of the order denying the motion. Defendants missed this deadline. However, default judgment is appropriate only when a party against whom a judgment for affirmative relief is sought has failed to plead or otherwise defendant within the time allowed, therefore, by these rules of statute in Minnesota Rules of Civil Procedure 5501B. The court may deny a motion for default judgment if the defendant has a reasonable defense on the merits, defendant has a reasonable excuse for his failure to answer, defendant acted with due diligence after notice of the entry of judgment, and no substantial prejudice will result to other parties. Okay, and found in Collar versus Guardian Angels Roman Catholic Church of Chaska in Minnesota, 1980. Further, Finden versus Claus in Minnesota, 1964. All 4 of these factors must be satisfied in order to justify relief under the rule. And that's where they go in Wynn versus State Farm Mutual Auto Insurance in Minnesota, 1997. And all 4 of these factors are present here. Okay, so we've got a decent argument. Let's give her a chance. She's putting forth an argument that she's saying, you know what? Yeah, we did this. We missed this deadline, but we've got these, and all 4 of these factors are present here. So let's say that. Now let's say defendants have a reasonable defense on the merits. Plaintiff's suit alleges that defendants' social media posts defamed them by characterizing a church they are affiliated with as a cult that engages in criminal conduct such as human trafficking, waterboarding, and kidnapping. Okay, I'm just going to make a little side note here. Remember, I know that people have came for me saying this is not about the church. Don't kill the messenger here. This is me narrating with my Dollar Tree crystal ball. I am saying what the lawsuit is saying and how Katie Joy lumps entire religions in, even if there are sects of the church, fundamentalist aspects of a church. Maybe the person is, it's just like people refer to the Bible and they pick and choose all the time. You can't say that this person did this because they're with the Catholic Church. But Katie Joy does, because she wants to claim that she's an atheist, because she claims that she has feelings that the Catholic Church is a cult. She lives in a very, very Catholic settled area that is very much honoring the founding families in that area. Catholicism is very, very well and alive in her area, as is Lutheranism. Nonetheless, Katie Joy has a problem with religion, so she tends to do this. And while I am speaking, I'm also saying that I do not believe for a second her dog chewed up that Bible. I think that she did it in a fit and then put it down in front of the dog and used it as a photo opportunity. Dogs even bow down to a Bible. I have not ever seen a dog go and chew up a Bible. Shoes? Sure. Couches? Absolutely. My cats have eaten at least 3 couches in their lifetime. But chewing up a Bible? Nah. Dogs aren't sacrilegious. Katie Joy might be, though. And that's my opinion. I'm sticking to it anyway. Defendants have a reasonable defense on their merits. Plaintiff's suit alleges that defendants' social media post. Okay, oh my God, this is so many S's. Sally sold seashells down by the seashore. Hold on before I do this for her. Sally sold seashells. Blah, 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 blah. Sorry, that was a little loud. I didn't mean to blah that loud. Blah. Hope you weren't sleeping through this. Well, now you're awake, and I've got to do this sentence because it has a lot of S's. So I'm going to take one more sip of my blackberry tea from the Quick Trip. I love that stuff. Okay. Here we go. Plaintiff's suit alleges that the defendants' social media posts defamed them. Okay. By characterizing a church they are affiliated with as a cult that engages. Okay, I just read that, but I want to go through this again. Engages in criminal conduct such as human trafficking. Okay, because this is the meat and bones, meat and potatoes, whatever. It's something about meat, where we are really getting to what they said, because she says a church that they are affiliated with. She defamed them by characterizing a church they are affiliated with as a cult that engages in criminal conduct such as human trafficking, waterboarding, and kidnapping. To prove a claim for defamation, plaintiff must prove that A, the statement was false. 2, it was communicated to someone other than the plaintiff. And 3, it intended to harm the plaintiff, lower him or her in the estimation of the community. And you know what? This is me talking again. Nothing could be further from the truth, as they have proven that she says that she won't be happy until they're ruined and they have nothing. So, back to the script here. We're going to talk about stump cheese again, because stump cheese versus Park and David and Company is a huge thing that they keep referring to. They really keep referring to stump cheese, and I should probably look that up. I'm going to write that down. I'm going to write stump cheese. STUEMPGES Park. And that was in 1980. Because they really refer to that. I want to see that, and I want to see that if the spirit of the law in 1980 is the same as the spirit and intention of law here in 2023, to see if that is a suitable argument. I might just take my happy ass back down to the community law library. Okay, so here we are. When plaintiffs alleging defamation are public figures, they must allege that the statements were made with actual malice. As I just stated, I think they were. New York Times versus Sullivan in 1964. Defendants claim that the social media posts in question were either, 1, true, and now it says truth is a complete defense to a defamation action, and true statements, however disparaging, are not actionable. Number 2 is opinion. Okay. Now the First Amendment protects statements of opinion from defamation claims. Or 3, are protected by public person and public controversy privilege. Okay. So you have to do all of these. You have to meet all of these. There are so many different elements of the case packed into all of this. This is a huge learning opportunity for all of us. I didn't have anything this interesting in all of my pre-law days. I was president of the Law and Justice Club. I was offered an amazing job at the prosecutor's office, but because I'm an idiot, I didn't take it. And in my whole undergrad, I never briefed a case that had anything this relevant and thought-provoking. So to me, being a student of life, I really like it. It makes me want to go back to law school. If I wasn't so freaking old. Anyway, a debatedly meritorious claim is one that, if established at trial, presents a cognizable claim for relief. Ordinarily, a claim must be established by more than conclusory allegations in moving papers. Appellants may establish a debatedly meritorious claim in an affidavit or by proof. And they reference a case in the Minnesota Appeals Court in 1984 that was reviewed and denied in 85. It says here, defendants are at a distinct advantage in establishing a meritorious defense in that plaintiffs have refused to engage in discovery. Plaintiffs have not answered discovery served on them August 5th, 2022. Plaintiffs have served no discovery on defendants. The deadline for serving discovery was August 5th, 2022. Okay, Jennifer Moore is putting forth a good argument because she's going to say, hey, you want to cite me for not doing this? Well, you know what? When the tables were turned and the dates were yours, what did you do? I didn't do anything different than you. Okay? All right. Rooting for the underdog in this hearing, huh? So, we go over here. Still, the allegations that defendants have made against the plaintiff have been the subject of intense media scrutiny. Scrutiny? Why don't I put a T in scrutiny? Wouldn't that be wonderful? That'd be a great new word. Scrutiny. Okay, I will do this one more time. Still, the allegations that defendants have made against plaintiff have been the subject of intense media scrutiny. Ms. Paulson stands ready to defend each and every allegation as true or opinion based upon true information. Media organizations have examined Ms. Paulson's allegations and independently verified them through interviews and public records. Oh, really now? Side note here, Utah Fox 13 just had to remove what they said about her and relabel her as an internet blogger. And the picture that they put up, they just did a little story. I'll try to link it in my community post. They put up a very, very unflattering picture of somebody, maybe an AI picture of somebody that isn't real, but maybe it's an artist's impression of Katie Joy. I don't know. It's terrible. I'll show it to you. Like I say, if Katie Joy's out there sending stories and trying to get them picked up so that she can be seen as an actual journalist, she's creating the narrative. She's padding her defense, okay? But now having the public opinion come out and say she's no journalist of mine. A journalist has ethics and morals, and she doesn't have any. So Utah Fox 13 will probably not refer to her as a journalist again. They had to redact that, and I'm going to try and find a link to that. It is hilarious. So anyway, I feel like if she's going to stand on everything as true or opinion based on true information, there is a huge burden of proof on her. But we know that Katie Joy will say she'll try to die on the hill protecting her sources, and she'll try and say that, well, this person didn't give up their sources and I'm on a hunger strike. I won't give up my sources. She made up the sources. How can we not prove that she didn't make up the sources? She will say that she's not going to reveal them. And what can you do? This case is going to garner national attention. As much as Wright County is a small little area where they don't think it will at some point if it goes to trial. Not at first. Not like any trial where you've seen that, people just lining up. But it will. Because this is a huge case about sources, internet rumors, internet, aka journalists, and what the definition of a journalist constitutes. Oh, look at this here. I'm going to take you upside down here. There you go. Look at how I'm looking over here. Blackbird Cauldron Supply Incorporated. It says right here, the Cauldron Supply is sustainable, social, and ethical. Well, those are some of the things that are important in a journalist. Is a journalist because they journal things? Or is a journalist somebody who is respected in the profession because they bring you the story with the facts and the truth? It's going to be really interesting to see what goes on. Nonetheless, if she can't prove her statements, she's in trouble. Go back to the script. Similarly, Ms. Paulson has raised sufficient facts to establish that has a bona fide, qualified, privileged. Okay, that doesn't even make sense. Similarly, Ms. Paulson has raised sufficient facts to establish that has a bona fide, qualified, privilege. There should have been a she in there to establish that she. Let's put in there she. There. Okay, she has a bona fide, qualified, privileged. I don't think that the D should be there. This just would read better if it said, similarly, Ms. Paulson has raised sufficient facts to establish that she... No, it still doesn't run. It would be, she is a bona fide journalist with qualified privilege. I don't know. I don't get it. And it says, okay, so then here we are where we're going to see that how she qualifies for that privilege. Ms. Paulson has a YouTube channel with 262,000 followers and an Instagram account with almost 88,000 followers. She is regularly cited and reported on in national publications such as People Magazine, In Touch Weekly, The Today Show, US Weekly, and more. Okay, that is going to work for the defense. What were her numbers when she started this? Let's see if this is helping or hurting her. Let's say that, okay, so in November of 2022, October through November, she had 262 on YouTube. And Instagram has 88K. Now, it says that she is cited in regularly in People, In Touch, The Today Show. The Today Show. Was that the one that I showed where she was talking about the straws? US Weekly. And more. Okay, let's see what the and mores are. Now it says Ms. Paulson is not the only journalist reporting on the controversy surrounding the plaintiffs. Stories have appeared in Rolling Stone, the Daily Mail, and the Daily Beast. Okay, so let's say here that plaintiffs have a story in Rolling Stone, the Daily Mail, and the Daily Beast. I will research that, and I will bring in all of that to say we'll look at who's doing what. I will get all of that information to you. You know that I will. And we'll see. Plaintiffs clearly view themselves as public figures, yes. According to Miranda Derrick, she has 1.3 million Instagram followers and 92,400 TikTok followers. Miranda Derrick at paragraph 13. James Derrick has 1.7 Instagram followers and 4.9 million TikTok followers in the Derrick affidavit. And the center of both Derrick's claims is that they should have more followers than they do. Okay, so they're saying that they should have more followers than they do. They don't have them because of her harassment. Now, can you say that a channel so little could affect them? I don't know. I mean, my channel is very, very little. Can I affect her? Probably not. But I like to make sure that there is the truth out there, even if it's not heard by many. At this point, if you like what I'm doing, please like and subscribe. It makes a difference to me. It makes a difference to the truth and the facts getting out there. All right. Upon information and belief, Robert Shin founded the Shekinah Church in 1994. However, since, okay, so he founded the church in 1994. Upon information and belief, Robert Shin founded the Shekinah Church in 1994. However, since he has launched a record label and a production company that has produced a number of Hollywood films before founding 7M Films, which is focused on generating web-based content for TikTok and other social media platforms. He has been the subject of a number of news articles in multiple publications. Clearly, he is a public figure for purposes of establishing a qualified privilege. Thus, defendants have put forth specific information that establish the existence of meritorious defenses. Defendants have a reasonable excuse for failing to file an answer prior to October 5th, 2022. Upon receipt of the court's order, counsel prepared and executed defendant's answer, but failed to serve and file it. This failure had two causes. First, counsel was anticipating that the court would issue an order providing a deadline that would then be docketed into the case management system. Second, counsel was unexpectedly called out of the office when his mother-in-law became very ill before he could ensure that the answer was properly filed in the Martin Declaration. Okay, this is what we were referring to when they tried the other excuse, because here they are, a year and a half later, and Jennifer Moore is in court going, I was on vacation. What was I supposed to do? And here she is writing this, that, that her partner had this. Excuses like that when you have a law practice are not acceptable to your client. Your client is paying you regardless of that. You could lose a whole court case on this. Politicians have lost elections and their place because they have not represented their peoples properly in making sure that actions are filed by a deadline. This is not okay. It's not an excuse. And I don't like Katie Joy, but I feel like they failed her on this part and they very much jeopardized the case. This is why it's a partnership, because I don't know. Are they married? Are Troutman Martin is more married to Martin? I don't know. Because then that would mean that it's her mother and whatnot. But it doesn't matter. You don't see this in a court case. You don't see something like this. You don't see them defending this. If the client had an issue, maybe. But this is not acceptable. I would have made quite the judge, huh? Anyway. A third contributing cause was that counsel for plaintiffs did not communicate in a way that it would be moving for default judgment if an answer was not forthcoming. While defendants acknowledge that plaintiffs have no obligation to remind opposing party of its obligations under the rules of civil procedure, it is a common courtesy to advise the opposing party of an intent to file a motion, at least to determine counsel's availability. Instead, plaintiffs were silent and their motion for default judgment came as a complete surprise to defendants. Oh my God. All right. Okay. No. At the way that they're going here, it is not their duty to tell you before they do it. They filed a motion. It was done. That's what they did. It's not their thing. Hey, guess what? I'm going to do something against you. I'm going to file a motion, so you might as well, perk up. It's not, that's their time too. No. You were supposed to do something. You didn't. And you know how Katie Joy loves to say, oh, no, it's not me. The other side isn't doing what they're supposed to. We've done everything right. They haven't done what they're supposed to be. They're in big trouble, and the judge is very mad. No. Nope. Your side has failed several times. Has the other side? Yeah, because they're dealing with this. They're like, why should I do anything when they're not? I mean, this is, so some rough stuff. Counsel acted diligently upon discovering the error. Plaintiffs filed their motion on Friday, September 30th, 2022. On Monday, October 3rd, 2022, counsel sent a letter to plaintiffs asking them to withdraw the motion for default judgment. On Wednesday, October 5th, 2022, counsel served and filed defendants' answer. Thus, less than 3 business days elapsed between discovering the error and fully correcting it. No, it was still a mistake. Nope. Plaintiffs have suffered no prejudice as a result of the error. Plaintiffs cannot possibly claim any prejudice as a result of a 1-month delay in 1 month? Okay. Plaintiffs cannot possibly claim that any prejudice as a result of a 1-month delay in receiving defendants' answers. There you go. So when Katie Joy says the other side isn't doing anything, you have this in a court filing that the plaintiffs cannot possibly claim any prejudice as a result of a 1-month delay in receiving defendants' answer. Okay? That right there impeaches Katie Joy's claims that the other side isn't doing what they're supposed to. They're not answering emails. They're not doing that. No. Over a year ago, this is noted by her own attorney right there. That, yeah, we did it. And so a month passed. So what? Nothing happened. Yeah, you're lucky. You're lucky that you have a very, very lenient judge here. I would not be that lenient of a judge. Says, they were fully aware defendants were actively defending the action. Any doubt could have been resolved with a phone call or email. Plaintiffs volunteered for any prejudice that they may have incurred. What? Whoa. She did not. She just said, basically, if you did this, you asked for it. Wow. Someone's real cocky there. Weren't so cocky in person. Ooh, bam. Conclusion. Defendants have a reasonable defense on the merits, a reasonable excuse for failing to serve and file the answer, and acted diligently immediately upon discovering that the answer was not timely filed. Plaintiffs cannot possibly claim prejudice when they did not even pick up the phone before filing their motion for default judgment. Based on the foregoing, plaintiffs' motion for default judgment must be denied. Respectfully submitted, Jennifer Moore. Dated November 4th, 2022. Oh, wow. Then we go back here. And we have the Minnesota Statute 549-211. And it states here that the party on whose behalf the attached document is served acknowledges through its undersigned counsel that sanctions, including reasonable attorney's fees and other expenses, may be awarded to the opposite party or parties pursuant to Minnesota Statute 549.211 in 2016. Signed again, Jennifer Moore from Troutman Martin Law, attorneys for the defendant Catherine Paulson, dated November 4th, 2022. I'm going to cut this episode as that and not go to the next part because I think that this is enough on its own as a very, very compelling episode. And I got to get back to eating my garden stuff. My cantaloupe turned out so good for my garden. My cucumbers are amazing. My garden was made possible by donations to my Cash App. Tabitha Jane 13. If you want to buy me coffee so I can get a pumpkin spice latte, please Cash App me at Tabitha Jane 13. And I will look forward to hearing from you for the next episode. Comment below and share away. Share my playlist. Share this episode. Share it on Reddit. Share it wherever you see it. Share it with your friends and your neighbors. Share it. Share. I will never tell somebody not to share my stuff. Thank you for listening. Bye-bye.